All right. Good morning, everybody. We will obviously see more people join in these first few minutes, but we're still going to kick this off and get things going. My name is Larkin McGowan, and I am the manager here in the Marketing and Field Support Services Department with Armanino, and so I'll just be handling some logistics, watching the chat. We really encourage everyone to utilize the chat in these Q&As. They're a bit more casual, a bit more fun. You'll have some open mic night type of activity going on. If you want to unmute yourself and speak up, there will be opportunity to do so. We want to hear your voices. So again, drop things in the chat as it comes up, as you listen. I really encourage just to kind of engage there. When something comes up in your mind, drop it in the chat. I'll be watching and we will find opportunities to bring those up to the forefront. So with that said, I am going to hand this over to Liam Collins, our risk advisory assurance partner. So he's the partner in charge leading that department. I'm going to let him introduce himself and then go on and introduce Pippa and Michael. So
awesome.
Off to you, Liam.
Thank you, Larkin, and thank you everybody for joining. As Larkin said, I run our risk assurance and advisory practice. We cover many different lines of service: cyber, SOX, controls automation. Data privacy is one of our larger and quickly growing practices, obviously with lots of complexity in the regulatory environment right now. So thank you for joining to discuss DSAR best practices, consent management. We will also give an update on the regulatory environment, specifically really CCPA. Also talk about some of the things we're seeing, especially now with COVID-19 and what companies are dealing with and some of the challenges. So I'm going to hand it over to Pippa and then Michael. I'm going to walk through some topics, but as Larkin said, this is very much open as Q&A, certainly not a webinar, so we don't want to be presenting all the time. Please chime in with your questions, your comments. We're here to answer anything you guys have on this topic, or I guess in general on the privacy topic. So thank you again, and Pippa, over to you.
Yes, good morning, everyone, and thank you, Liam. My name is Pippa Rakem. I'm a senior manager in the RAS practice group, chiefly focusing on privacy, helping companies. My passion is helping companies to meet their compliance goals in the area of privacy. A lot has been happening in this space, and this is a good opportunity. This is a good time to try to walk through some of the challenges that are facing organizations given the current pandemic. We've been leveraging quite a few tools to help clients to meet their compliance obligations. We have as a guest speaker, Michael Williams with Climb Platform, one of the tools that we're leveraging for DSAR and consent management. Michael, I will let you speak. Introduce yourself.
Thanks, Pippa. We really appreciate the invite and the opportunity to participate. I'm Michael Williams. I'm a partner at Climb. I'm also a California licensed attorney. And Climb is a data privacy compliance platform that we have built for companies to be able to comply with these data regulations as they come out. CCPA, GDPR, I'm sure you've heard all the acronyms, and we're here to help get companies compliant with all of these data privacy regulations as they continue to roll out.
Thank you, Michael. So today's presentation is really about understanding the challenges facing organizations during this period of unrest, given the fact that a lot of business systems are remotely being accessed and there are limitations. And as a result of that, there are challenges posed to DSAR and consent management workflows. So it's really about trying to understand how your workflow, how your processes measure up to other peer organizations, and also trying to understand what it takes to have a fully functioning DSAR workflow. As part of the discussion, we will be looking at technology solutions around some of the more manual processes that companies often have. And given the current challenge, it's very impossible to try to manage your manual processes without some technology solutions. So with that, we will look at some of the options around automation and simplifying your DSAR process. So for takeaways, it's all about building a responsive DSAR and consent management workflow. So this is an informal conversation. Feel free to chime in as we go through the slides. Next is the update. As I earlier mentioned, there is much happening in the regulatory space landscape. And many of you on this call may be familiar with the new CCPA 2.0, or more formally known as California Privacy Rights Act. This is not yet a law, but there is a referendum likely to pass come November. There are many changes that will come as a result of this referendum when and if it does pass. There is a lot of that information on this slide. I'm not going to go through all the bullets, but it's just to keep in mind as you have built out your compliance systems and compliance processes to fulfill your obligations under the CCPA. There may be new requirements clarifying the regulation, CCPA, and in many ways also attempting to clarify how businesses meet consumer rights and how businesses should have processes built that address those needs. A lot more to come on CCPA 2.0. And with that, I will go on to the next slide. With enforcement, much is still unknown about the July 1 enforcement, if it is going to take place. Right now, it's still on track for July 1, and I say it's an if because there is not yet the final regulations. There are pending laws that attempted to clarify the many ambiguous provisions of the CCPA. July 1 is the start-off date to enforce those provisions, but unfortunately, the Attorney General, the California Attorney General, has yet to finalize those regulations. But to keep that in mind, it doesn't stop enforcement. So if you are yet to get on board with your CCPA preparations, or if you need to audit your processes to see how they measure up to CCPA requirements before the July 1 date, this is a good time to keep track of that.
Pippa and Michael, quick question for you. What does enforcement look like? Though we know it doesn't, it may or could technically start on July 1. What does enforcement look like or feel like?
Enforcement will feel like or come in the form of a complaint. It could also come in the form of a class action lawsuit. So something as simple as a consumer visiting a website and looking at the privacy statement and seeing the commitments or disclosures of the privacy statement and then submitting a DSAR request. Inconsistencies based on what returns as a result of the DSAR request compared to information in the privacy notice. If there are inconsistencies, that can lead to a formal complaint with the State Attorney General. Now, there is a period of remediation, 30 days grace period for a company to try to correct the non-compliance issue. And then thereafter, there is enforcement action, and depending on whether or not it resulted in a breach, it can lead to other consequences. Mike, do you want to chime in on that?
No, I think it's great information. For enforcement purposes, my mind immediately goes to the financial penalties that are involved here for each incident, up to a $7,500 penalty. And I think companies of all shapes and sizes are concerned about their bottom lines, especially over the last couple of months. It's been amplified how much businesses need to be concerned about their bottom lines. And just to put it in context, since it was enacted a couple of years ago, GDPR has levied over $500 million worth of fines. And so I think California companies and companies that need to be in compliance with CCPA in general need to be concerned with the financial penalties that could result for their organizations as a result of non-compliance with CCPA.
And the fines are not what any organization, to echo what Mike has said, it's not what any company at this present time wants to entertain. So it's truly an area that companies need to focus on to make sure that they have systems in place that comply with this regulation. So I earlier mentioned that there are many reasons leading to why we're having this discussion today. A lot has been going on in the privacy space that is driving the sort of fines that Michael previously mentioned, and that is driving regulation. Unlike a few years back, pre-GDPR, there are and still consumer protection laws, but they weren't really at the level, awareness around them wasn't at the level that you now see since the adoption of the GDPR. So what GDPR has done really is to shift the privacy culture for business, to shift the focus for the consumer, to make consumers more privacy aware, more rights aware, demanding more control over how companies use their information. And some of the global regulations that have impacted that whole process include PIPEDA, GDPR, PIPEDA of course is Canada, LGPD, Brazil, POPD is Hong Kong. We're seeing a lot of traction in that area of law. And you have India's data protection law as well, that is gaining traction, and Chinese privacy laws. All of these are having impact on how consumers think. And when you look at the fact that you have more than 1 billion people living in these jurisdictions that are, that do have these rights, I mean, it's really beneficial for a company or companies operating in these jurisdictions to take care to have systems in place. Of course, we have the CCPA. The CCPA is one of those regulations that is precedent setting. It is a copycat regulations for other states, and even might lead to to a new federal law. So it's a regulation that cannot be ignored. And as with other privacy regulations, you have data breaches provisions, and the last points there on the slide, companies, instances that have led to very huge coverage in the media. The Cambridge Analytica case, I was actually reading an article this morning that the Canadian commissioner has agreed to settle with Facebook in connection with this case. And the Cambridge Analytica case was a case of unauthorized use, not having proper consent. The British Airways case, data breach involving a vendor company, Marriott International, Equifax, Capital One. All of these are instances of breach, and all of these are driving awareness around privacy laws and rights. So just to summarize the trend, a few years ago, if you look at this map, a few years meaning 3 years back, if you look at this map, it was mostly gray. You would hardly see any color. Well, this is all changing, and this is changing with the CCPA. And next door, of course, is Nevada. You are looking at Texas, you are looking at Louisiana, Arizona. So in essence, the trend is more privacy regulations. This is unrelenting. So as a company, you really want to be aware of what's happening in the landscape, the regulatory landscape, and how this has impact on your business. And so I just want to open up the mic to the audience in terms of the changes in the regulatory landscape. What sort of impact are you seeing on your organization? How has that changed your processing activity? If anyone can chime in.
And don't be shy, you can self-unmute if you would like. But it would be very interesting to hear from a few of you in industry on what you're seeing. Okay, well, we'll take that as either technical difficulties or not so sure they're here to listen. But maybe Michael or Jeff.
Yeah,
Yeah, I mean, I think the challenge, I mean, look at the colors on this map and the slide before talking about the international laws that everyone is expected to comply with. The challenge is just keeping up, right? A lot of the potential customers that we have talked to and that have since onboarded to Climb is, you know, they were trying to manage all of this compliance internally, and that's a significant hurdle because number one, it's not their core competency, and number two, it requires so much resources to keep up with all the changing regulations. I mean, we're looking at a 50-state framework just in the US, and that's before you get to Canada's laws and the EU's laws and all these other things. All these laws have nuances, and so there's no real one blanket approach that any company can take to be compliant. And as we talked about before, the risk of non-compliance is severe, given that the penalties in each jurisdiction can and probably will impose. My expectation as the California Attorney General will impose strict enforcement of the CCPA, and that's going to cost a lot of companies money for being non-compliant.
thank you. Larkin, any questions in the chat box that we need
not
to?
right now.
Excellent, thanks. So moving on to privacy rights, when we look at data access requests, we are looking at a set of privacy rights that are given to individuals for them to have control over their information, for them to have access to question how their information is being used, and in certain instances, request restriction or further processing of that information. So what you see before you is a combination of rights that we see broadly across various privacy regulations, from GDPR to LGPD to CCPA. You always have a beginning point of right of access. I need to know what information you have on me. And then the right of rectification is more in line with the GDPR, but I raise it here because of the CCPA 2.0. This legislation, this referendum, if it passes in November, moves consumer rights closer to CCPA rights. And there is a provision to rectify any inaccurate information a company may have around you. You also have a right of erasure, right to be forgotten, right to restrict processing, right of data portability. This is often with recent developments around GDPR, the right of data portability has often been a huge gap for companies because it requires some engineering work. It requires you to have mechanisms in place that can transfer information you have on your consumers or make them available in a format that allows them to transfer and view and use the information you've collected about them. So companies are struggling around technology. And then you have GDPR right related to automated decision making and profiling. The only request is when you use AI, be mindful of the fact that they may have a legal impact. They may prejudice your consumer rights, your customers' consumer rights. And so there needs to be some further intervention down the line, maybe a human being to take a look. At least that's the requirement under the GDPR. And then with right to equal access, this is a CCPA requirement, and also a section in GDPR, but more CCPA focus, where if you, as a data subject, exercise your rights, that should not result in discriminatory practices, not having equal access to services. So consumers are very much aware of these rights as a result of all the breaches and changes that are taking place. So leading to
Pippa, can I interrupt you real quickly with a question?
Yes,
and Michael as well, with regards to right of data portability and that being the most challenging one that organizations are facing today. What are some types of ways that organizations are finding compliance here? Or if it's very challenging, how are we able to, you know, get on the right side of this right, per se?
Michael, do you want to address that with Climb?
Sure. So, I mean, from our perspective, you know, it's an important right because it allows individuals to obtain and, you know, reuse their personal data for their own purposes across different services. And, you know, I think step one for us, and we can show you a little bit more about the tool later, but it's about, I think the first step in any of these processes is getting the request to the organization and having that be fulfilled, right? So if I'm a website visitor, and I need a mechanism by which I can actually make that request. And what we're seeing in the market is that people don't even have step one completed, right? So there's no mechanism that a lot of these organizations are providing to make that request available. And if they are, it's through email, which gets lost and it's more difficult to manage and that sort of thing. So I think step one here for any organization is providing a tool for a consumer to make that request, and then being able to properly manage and address that request in a single platform. I think is the first step towards achieving or being able to comply with that particular right of consumers. So Pip, I don't know if you want to add.
Yeah, absolutely. I mean, you need to have a process. You need to have a workflow developed around these rights. You need to be able to document your response to handling of a data subject request. You need to be able to demonstrate to a regulator that you did respond in the allowable statutory time. And so when you look at what needs to be in place to help support that process, you really need the technology. You need the people. You need a process that is scalable. You need a process that is easily accessible to the data subject. So it's all about engineering the right mechanism and making sure that it does support and prove out your compliance with the regulation. So now we are moving from rights of data subjects to some of the challenges that are impacting how companies are processing or able to manage requests that flow in. We obviously are in an era where a lot of unprecedented action and events and mitigating approaches need to be thought of and implemented. So what we are seeing, not only with clients, but with companies sampling opinions out there, is that furloughs are having an impact. Layoffs, illnesses of employees working remotely is having an impact on how companies are managing their DSAR requests, or if they're able to manage their DSAR requests. So when you look at a company that has manual processes in place and suddenly having your employees work remotely, it's almost an impossible response. There's almost an impossible response there. So it's about trying to take that manual process and automating some controls around that process to allow you to fulfill your rights. We're also seeing that companies are having issues with legacy systems that give them very limited access. And so they would have to have someone on site to manage those systems, to research information on in those systems, to be able to respond to DSAR. We're also witnessing competing business interest, where trying to keep the company afloat is often the priority compared to other compliance obligations. So there is an issue there with priorities, and the recommendation we are making to compliance advocates or privacy advocates, champions, whatever the company title you hold, is to make compliance, make your issue a priority, because just because there is a pandemic doesn't remove your obligation, your legal obligation to fulfill a request. And for those companies, there are still companies that have paper records, paper files, and it's truly a challenge. And they are coming and asking, how do we digitize our forms and make this process more efficient? And overall privacy awareness is very high. Employees, consumers are very much aware of their privacy rights and what they should disclose or what they want to disclose in connection with COVID-19. Something as one would think, disclosing your temperature, your employer being able to take your temperature does create some privacy concerns. But again, there are exceptions. There is a public awareness, public safety exception under the law. So it's all a matter of really planning out how you respond or should respond to a DSAR process. And lastly, what we are seeing is the pandemic fatigue, where everyone is just, trying to adjust to this new environment we find ourselves. Larkin, let me open up the mic to see if there are any questions, feedback, any points to share on this, on some of the challenges some of our attendees may be having with their processes.
Nope.
Any questions in the chat room?
Nothing in the chat. I thought I saw someone unmute themselves, but is there any specific questions surrounding this, audience? Okay, I think we're good.
Moving on to the next slide. We've talked a lot about DSAR, data subject access requests. There is also that larger issue of consent. And this resonates greatly with the GDPR, where if you are processing sensitive information, you need explicit consent. If you are processing special categories of information, you need consent. Special categories of information, religion, any sort of political, gender, orientation type data, you need some sort of consent. And even before then, consent is also required if you are processing information of an EU citizen. So I've given a summary of the consent, the definition of consent under the GDPR. With the CCPA, there are specific areas where consent is required if you are dealing with children's data, if you are selling personal information, plan to sell personal information, you need to provide consent to make the consumer aware of that fact. If you are also intending to provide any type of rewards program, you need their consent, you need your customers' consent prior to including them in your rewards program. And companies are facing challenges. One of them is cookie walls. Cookie walls, when you visit a website and before entering into that site, having to consent to having your information collected. GDPR EU is really taking up this issue and has issued some guidance around that. There is also the issue of tracking consent. Do you have the proper mechanism to track consent and to track the withdrawal of consent? So all of these issues really, if you're a company processing or dealing in personal data, you need to ensure that your data protection program, you have a system, the people, you have the processes, and you have the technology that ensure your compliance, that help you to achieve compliance with the regulation.
I actually have a question, maybe even Climb, you guys can speak to this, but I have a question just from a operational standpoint. I feel like there's size of companies, companies I've worked for at a certain size that they may or may not, or I will say they may not have the resources to put full-time staffers, take on SaaS products, process. I mean, these are really huge subjects we're facing. It's global data, the abyss of the internet subjects. What's the conversation happening, both maybe as a SaaS provider or even among regulators? In theory, these are all great and they make sense, and as an individual, it makes sense. From an operational standpoint, if I'm a CEO or an operations COO type, and my company hasn't hit a certain size to manage this, I mean, what is the conversation happening?
Well, I mean, from our perspective, I don't think anything takes the place of like quality consulting services, but you've essentially hit on the reason why Climb exists, right? I was formerly part of an organization, as that spent 6 figures on just GDPR compliance, and that's let alone CCPA. And we felt that most organizations needed a better solution.
Yeah.
And obviously, we're a part of the solution that needs to occur, but most organizations don't have that kind of checkbook. And even the ones that do want to be able to mitigate whatever expense they have in this area. And as more regulations come out, if you're trying to manage this internally, it's just the costs are going to be endless, right? So that's why you need a combination of consulting, but also a platform to be able to be flexible as these laws come out and continue to change. I mean, we've seen modifications to CCPA in the last few months HIPAA mentioned the cookie wall guidance for GDPR. Those are things that if you're trying to handle those things internally, the costs are going to be out of control. And also just time, headaches, all of those things are going to increase exponentially.
It's quite the challenge. You know, we had some roundtables last year, and we had some very large known name brands, you know, at the roundtable. They have entire departments dedicated to this. So I think, you know, because Armeninos, we have so many mid-market companies we support that, you know, that's my immediate thought is how are they going to move through all this?
Well, I mean, from a compliance perspective, I think it all starts with organizing your team. You need to have good understanding of the personal information flow through your organization. And so it's good to tap into the leadership of those organizations. And typically, we see legal, we see the accounting, finance departments, HR departments, we see IT. So wherever information flows in from or is stored, you need to have stakeholders from those departments. And then you need to begin to have an open conversation on how these regulations would impact their processing activities, to have good understanding of that. And if you don't have the bandwidth or a clear understanding, or if you are having any challenges with communicating what these requirements are, you then seek to outsource. You may want to invite someone, data experts, Amanino, of course, and Klein, to help to navigate your path to compliance. And after you realize that, well, you have a team, there are additional steps to take. You need to have an assessment that gives you clear understanding of your current compliance posture. It involves a thorough analysis of your privacy and security controls and identifying the gaps and making recommendations around what can be done, prioritizing the remediation plan, and gradually implementing and monitoring and training. So there are a series of steps, including technology, to help organizations transition into ongoing compliance.
If I can just jump back in for 1 minute, somebody said something to me the other day, and I'm going to butcher this a little bit, but the paraphrase is, complying will cost you something, not complying could cost you everything, right? So as a business, there are going to be costs for compliance, and we try to be a cost-effective solution and platform to manage the ongoing compliance for people's websites. But I think the focus should also be on the potential financial penalties that derive from violations of CCPA or GDPR or whatever regulation we're talking about. So there's the cost of compliance, but there's also dealing with this in a non-compliant way could have a much, much larger impact on the finances of any company.
Yeah, to get back, Pippa, to the slide that you had before about, you know, the current situation that we live in with COVID-19.
Yes.
That's just additional stress and worry for that mid to small size market of things that they've already got going on. So I think it's our job and our responsibility to provide that education, but also to provide it in a way where they can understand and digest the information, because this is a foreign language for most of the people that we come across. So we've really got to be proactive in that communication and conversation, and just, you know, bring it to a point where it makes sense for people.
Thank you. So I think this is a good segue into the Klein platform. So Mike?
Sure. So, you know, CCPA and some of the other privacy regulations that we're talking about they're applicable to across industries, but we get a lot of requests from companies in these for particular spaces: hospitality, real estate, tech, and e-commerce. And for us, it makes sense why these companies would need to be focused on data privacy from a global perspective, regardless of where their business is physically located or geographically targeting. And that's because most data privacy regulations have their basis in the residency of the individual, right? So a hotel located in Las Vegas or Orlando likely has visitors from California or the EU and is probably collecting data from those individuals that's protected by CCPA or GDPR. Likewise, I live in Los Angeles, and in my neighborhood, it's not uncommon to hear a dozen languages spoken every day because people from all over the world buy homes or other real estate properties here. Similarly, e-commerce sites sell and ship their products to individuals at least nationwide, and many ship internationally. All of these industries are posed with significant problems in terms of trying to keep up with their compliance activities. So the issue, as you see below, is how can your website or company achieve compliance in an ever-evolving landscape given these global challenges? So if you want to jump to the next slide, and Jeff Atwood's going to join us here as well.
Yeah, I think if you could go down one more slide. I think we were talking about kind of the global.
Sorry.
That's okay.
Okay.
So here when we talk about, you got to think global for a second. And, in the ever-evolving landscape of data privacy regulations, the question usually is how do companies ensure that they're compliant across the globe? And for us, really, that boils down to flexibility. You've got to ensure that whatever technology that you're using has the flexibility to not only handle the new regulations that continue to take shape, but also to have the foresight for existing regulations that will, undoubtedly encounter challenges and will need to, have updates and changes. There's different regulations for different countries. In some countries, or in some areas like the EU, where you have GDPR, your visitors are required to opt in, which means they explicitly give their consent to run non-essential scripts on your site. But others, you're giving the visitor the choice to opt out. So, this means that scripts are running in the background, and you're only going to be turned off if the visitor actually manually opts out. It's just an example, but the point is that you have to have the ability to create different rules for different regulations. So here on the slide here, you can see that, in this particular case for this site, we've set up different opt-ins and opt-outs and, data subject request capabilities based on the regulations for a given country. And the way that we handle this is we're able to identify the user's IP address, and based on their IP address, we are showing the widget set up in the manner that accommodates the regulation for their area. We even do have, for instance, if you've got someone, maybe an EU citizen that's visiting the United States, and so the IP address is going to be the United States. Well, we've got the ability to go in and to change your settings so that you can identify yourself as an EU citizen, and then you would have the same look and feel as if you would if you were back home. So, I think it's really extremely important to have this flexibility because it's constantly changing and evolving. Pippa, could you go to the next slide, please?
Yes.
Excellent. Can you go back to the UI one? I think it was 2 up. There we go. So for me, this is probably the greatest challenge in our space. Everybody understands that you need to be compliant, but at the same time, you don't want it to look like a stop sign. You don't want someone to think that, by continuing, you're entering at your own risk. But conversely, you also don't want to put an encyclopedia in front of somebody with a bunch of tabs and data that's not necessarily relevant for every single person, right? industries are different. You know, your e-commerce, your goal for e-commerce is to get people in and browsing products as soon as possible. Whereas maybe healthcare and banking, you've got to be a little bit more conscious about making sure that people understand exactly what they're giving consent for. So we've made great investments to give our customers the flexibility of changing their look and feel, and also be cognizant of keeping within their brand guidelines as well. Next slide. One more. There we go. So it's a lot of data that we're talking about here, right? You know, storing and visualizing that data. You need to have something that's robust and intuitive. So, you know, if you need to deep dive into, you know, finding a specific consent receipt, to just running basic reports on total number of consents or total number of requests, or how many new requests are coming in or how many are open. Our dashboard provides all of that, in addition to, you know, being able to change your settings, being able to add information about, maybe you've appointed a DPO officer, maybe, you know, you've got documents, privacy documents, or terms and conditions. This is kind of a one house holds all type of platform, so that you can manage, or your colleague can manage that all in one place. You know, it's I think Michael and I always have a running joke that, you know, emails and Excels only get you so far, and I think that goes a long way. We've had a lot of conversations with folks that have, you know, they've hit that wall. It's just like any company, you go through growth. At some point, you hit the ceiling of I just can't manage it anymore, and it's kind of what spawned the birth and interest from Michael and I on Climb. So, next slide.
Hey Jeff, are you seeing any best practices where, you know, maybe how many staff someone is able to put towards this? Like, is it one full-time staff at this size, or I don't know, are you seeing anybody address this well? Transitioning into it?
Yeah, typically, honestly, at the beginning, a lot of clients are leaning on us to certainly walk them through, and what we do really well is we provide group trainings, but we also do individual trainings. You can imagine right now, within certain companies and certain there's a lot of turnover. And so what we are noticing is that clients are wanting more than one person to be trained, just because a lot of other things are in flux.
Yeah.
But you know, again, we've made a lot of investments in the system to make it intuitive. So if you are familiar with using any type of CRM or CMS, whether it's MailChimp, HubSpot, Salesforce, you're going to have a lot of familiarity of how it works and functions. So we haven't got a lot of pushback on that, but we certainly do offer kind of a white glove service as well.
Mm-hmm. Cool.
We only have a few minutes left, so I'm going to move a little bit more quickly on this slide than I normally would, but this is where really the rubber meets the road. You know, when the California Attorney General comes knocking on your door about your company's CCPA compliance, or a regulator from the EU asks how you're handling data subject requests, you know, imagine the time and expense you're going to incur putting all this stuff together if you're managing it via email or via, you know, using Excel and Microsoft Office tools. It's just not a scalable solution, right? So a couple of things we do: manage data subject requests directly on your website and through our platform. That's on the left there. The middle shows the type of consent receipt that gets automatically generated when consumers opt in or opt out of data collection on your website. And then also on the right there's a mapping tool showing if a data subject makes an access request, what are the steps necessary to comply with that request, right? So it's mapped out for the user. You can communicate with the tool, with that data subject. So it's all housed in a single source so that if any regular comes to your door, you can just say, here's what I'm doing, and you can prove compliance in that way. So want to leave some time for some questions, so that's it for Climb.
Larkin, do we have questions?
We don't. I think everybody's just, soaking it all in.
But listening to you all, I definitely, and unfortunately, if you get to the point, Michael, that the AG is knocking on your door, that would probably be, I don't know, it sounds really scary. What would be step one if that were to happen? I mean, I guess if you were totally compliant and you knew you knew you were bulletproof ahead of time, I guess you feel fine. But what does that look like? Kind of walk us through the process there.
Sure. Well, I mean, it's going to be interesting to see how the AG's office actually handles enforcement. We're anticipating strict enforcement for a number of reasons. But if an auditor or a regulator comes to your door, you have to be able to show them that you implemented the proper processes and protocols to prove compliance. So they're going to ask, did you have a mechanism for a California resident to make a request? Where is that located on your site? Where is that in your privacy policy? Are you telling people what information you're collecting? How is that information used? All of these things, if they're housed in a single source, are going to be much easier to prove that compliance, right? So they're going to ask, how many, can I see when person X made this request? How long did it take you to comply with that request? How did you handle that? And having those workflows outlined in a single source and having a mechanism, a platform that's available to be utilized to show that it's going to be incredibly important. If you're showing them spreadsheets and Word documents or handwritten notes, that's just not going to work. It's I don't know if anyone's ever gone through an IRS audit, but the more put together you appear, the more people the IRS auditor is going to say, okay, we get it. And if you have a shoebox, they're going to shake their heads. So we don't want you to have the shoebox, is what we're saying.
Absolutely. And to echo what Michael has said, I mean, you need to be able to demonstrate compliance. With all the solutions that are available in the marketplace, not all solutions are equal. And you need to be very thorough based on your environment in choosing a tool that can help you establish and demonstrate compliance in the long run. You need a solution that can scale your DSAR process. So it's good to keep that in mind. Any questions? Larkin, anything in the chat room?
Oh, we're pretty good.
Let me ask one more question in our last couple minutes. If someone has felt like, their organization, they feel like, man, we don't have to comply, and now they're thinking, okay, maybe we do need to comply, and they haven't really gone through the first steps. What would that first step process look like, and how do we reach out to the two of you to kind of make that assessment or figure out how do we get compliant here very quickly?
Well, when it comes to whether your organization is in scope, the process begins with an assessment. An assessment is there to help scope your organization's processing activity to see if it meets the threshold requirements around collection, 50,000 or more, revenue requirement, 25 million or more, or if you are selling 50% or more of the personal information that you collect. This is per CCPA. And then with GDPR, we're looking at an organization, any entity that is processing personal information. You need to inventory your data ecosystem to understand exactly what information is in scope for which law, and how to either limit your liability by not collecting that particular information. But if it's vital to your business, making sure that you have a legal basis for collecting that data. So all of that comes through an assessment, pointing to your current controls and pointing to your gaps and pointing out the remediation that needs to take place. And to Michael, the technology side, if you want to chime in on that.
Yeah, no, I was going to say, because there's so many, CCPA has some threshold requirements. New York Shield Act does not, it has some small business components to it, but most, if not all, organizations, for-profit, nonprofit, are going to be included there. So I think it is having an advisor that is able to assist and be able to answer some of these questions and to kind of scope out potential projects is number one. And then having that, working with that advisor and a technical platform to make sure that you have a scalable solution is the next step, because you don't know today. I think a lot of people in February had an idea of where their businesses were going, and maybe now they don't, right? So it's those that could mean exponential growth. It could be, emerging markets. It could be moving geographically. It could be creating a remote workforce. There's so many things that are in flux right now, and everyone's going to need a technical solution that's scalable, and that's also cost effective. And that's where, a platform like Climb can be very helpful for a lot of organizations. But I think the step to echo Pippa's point, the first step is getting in touch with your advisor to determine, what regulations apply to your company.
Awesome. Well, this has been very, very interesting, very cool, also sometimes overwhelming. So I hope that everyone that's listening learned something new today. But Pippa, do you have any last thoughts for us before we sign off?
Well, first of all, I hope everybody keeps safe and well. And thank you for joining today's Q&A. If you have any questions, please reach out to me, Liam, or Michael. You have contact information. I'm actually going to the last slide on the screen. Here it just isn't cooperating. But to thank you all for joining today's Q&A, and have a good day.
Yeah, thank you, everybody.
Thanks, everybody.